Okay, good afternoon, everybody. Welcome to the first ELR seminar that we're going to be doing monthly, at least until we run out of things to talk about. So I have a feeling we're going to be doing these for a while. This first one is about just cause, which is the standard by which the university holds itself in our collective bargaining agreements and our policy to issue discipline to our staff employees, or at least most of our staff employees. And kind of how that fits into our goal of creating a respectful and fair workplace. So a couple things before we start. First is I'm going to go pretty fast. My goal is to get through all of my material in 20 minutes because my core goal with this is to provide staff and supervisors and managers an opportunity to ask real-time questions and get answers, right? So we're going to be doing 20 minutes or so of material, and I'm going to go through it awfully quickly, and then leave 40 minutes for any questions that anybody has. If we run out of questions, I have a case study / scenario that we can put up at the end of it, but I'm hopeful that we'll just have enough questions that we'll just go through the whole thing. So, advance, there we go. Okay, so before we start, this is our first go around, so very much appreciate any feedback that we get. We're dealing with technology. We are live streaming this, and we are, well, just the audio is live streaming, and so is the PowerPoint. We're also recording this audio only, and we'll be posting it on our website afterwards with an index. So folks that are looking into questions about just cause, we'll be able to search the HR website, find this audio and the slide deck, and be able to kind of go back and recreate this and hopefully get some of the lessons learned from today. So the online guests are muted, but they can send in questions. I'll be kind of pinging back and forth between online and in the room questions. Questions are great, but please hold them to the end because I'm going to try to blast through about 20 minutes worth of material. I'm asking that folks don't ask personal or confidential or kind of individualized questions. I've done a lot of these seminars, and it's not uncommon that I'll have people say, hypothetically, my boss does X, Y, and Z, or hypothetically, I have this employee that does that. It's not helpful to do those things. If you have actual kind of individualized questions, I'll hang around a little bit afterwards if you want to get with me. But please let's be cognizant of, we could be talking about confidential personnel issues. We do have microphones for our in-person guests, although I think, and that's so that the folks online can hear, so we're doing questions. For in the room, we'll be handing those out. There's a sign-up sheet at the door. We're only going to use that for sharing information about future events. We're not going to retaliate for anybody being in the seminar. And please silence your cell phones, which of course I've forgotten to do, so now I'm going to do that. Okay, moving on. So I'm Steve. I'm the Executive Director for Employee and Labor Relations. I'm a 14-year UC employee. Started out actually in business contracts over the Davis campus, and then was a labor consultant, and then spent 6 years as the ELR manager just for the Davis campus. I spent 2 years over on the Sacramento campus and the Davis campus as the Executive Director of Employee and Labor Relations. I'm a reformed attorney. I think a lot of people leave public sector to come or private sector to come and work for the university. I very much like my job a lot more than I did when I was a plaintiff's attorney. I am an alum of King Hall and the Graduate School of Management. So UC Davis got some of my money, still is getting my money every month. And I'm a golf fanatic, and I wore my golf tie just in case people were going to question me on that. Okay. So, what are my basic employee rights? So, there are lots of different types of employees at the university. And so all I'm talking about is staff employees for this. We're not talking about academics. They're basically, there's lots of different types of staff employees too, but the first one we're going to talk about are the contract employees. These are the folks that have not applied for a career appointment. They have a contract appointment that has a specific end date. These are strictly at-will employees because in the contract that they sign when they work for us, it says they are at will. They can be released for any legal reason without notice. So when I say legal reason, that means we can't say, we don't like Catholics And so we're going to fire you because you're a Catholic or because your nationality or any protected class or activity. But for any legal reason, we can just release those folks anytime we want to. Probationary period employees. These are folks that apply for career positions, but they typically have a 6-month, unless you're a police officer, then you have a 12-month probationary period. During your probationary period, you are also an at-will employee, and we can release you for any legal reason. The supervisor should provide some information to you about your performance along the probationary period, typically around midpoint, but there is no requirement that we have just cause in order to separate them. And finally, career employees, and these are non-management and senior professional employees or staff employees. So MSPs, there's a lower standard, so it's actually easier to get rid of somebody the higher they go in the organization. But career employees that are non-MSP, and these are the represented and the non-represented staff, they are held to a just cause standard when we issue discipline to them. So what this means is that, and this is based in university policy, it's based in our collective bargaining agreements, and it means that we can't take a disciplinary action unless we have just cause, and that's what we're going to be talking about today. Okay, so positive work environment. In my mind, the goal to all of the work that we do with employee labor relations in dealing with the grievances, dealing with advising departments is all around building a respectful and fair work environment. If you don't have that, you don't have productivity, you don't have strong performance, recruitment is harder, retention is harder. It's harder to actually have the business and the university reach its mission goals if we don't have a respectful and fair work environment. And what I found is that frequently when there are problems in the workplace, it's because there's not a strong foundation. When I'm talking about a strong foundation, I mean a respectful and fair workplace and an engaged supervisor. So a supervisor who is setting clear and reasonable expectations, is communicating well, both timely with positive and the negative. Frequently we get complaints about supervisors who only have the negative, you didn't do this, you didn't do that, instead of saying you did a great job in this instance and having a balanced approach. Okay, so it is management's responsibility to build and maintain this work environment, right? So staff should have that expectation when they come into the workplace that they're going to be treated respectfully and fairly. As far as building it, we all know the golden rule. How would you want your boss to treat you, right? If you're not treating your employees as a supervisor like that, then there's a problem. So that's kind of the starting point. Years ago, I created a Just Cause seminar that I did with our former director of ASAP services for the Davis campus. And she provided some great material that has been worked up. She was an organizational psychologist, and she brought in some of these core values and needs that employees need to have in the workplace in order to feel safe. And the reason why employees need to feel safe in the workplace is because we have, and I'm no psychologist, so whoever's listening who's a psychologist who's going to berate me for getting this wrong, do that in the evals after the seminar. But there are certain core values, and if you don't, if the supervisor or management does not adhere to these things, it creates a threat response for the employee. It's almost like, all the way back to kind of animal, threat reward spectrum. And the brain, and again, I'm no psychologist, but the brain can't differentiate between a threat from a tiger and a threat from an overbearing supervisor. The chemical reaction in the body, as I understand it, is identical. And so the things that we want to look towards in order to make sure that we have a productive employee these are three of the core functions, the core values. So there needs to be fairness. Employees need to know that if they do something at a certain level, they're going to be treated the same way as somebody else that did the same thing at that level, right? So if the rewards need to be reasonable, the accolades need to be similar for similarly situated folk. It can be, I typically show this this wonderful video that we don't have time for today about capuchin monkeys and this wonderful experiment they did where they basically give one monkey cucumber and give the other one a grape. And the capuchin monkeys like grapes a lot more than cucumbers, and the capuchin monkey throws the cucumber back at the lab person when she doesn't feel like she's being treated fairly because she's getting less of a reward than the other monkey. So it's kind of very basic, and I know that, but we need to make sure we're being fair. There also needs to be certainty in the workplace. The employee cannot not know what they're going to encounter when they come into the workplace. It can't be one day the supervisor is happy and open and caring and communicative, and the next day they're having a bad day and they're sullen and insolent and snapping and that kind of thing. Employees need to have certainty in their workplace about what they're going to encounter, and they also need a level of autonomy. This goes, all the way at the end of the spectrum. We're talking about kind of micromanagement, right, which is the opposite of this. Employees need to have some level of autonomy to be able to do their work without feeling that somebody is straight over the top of their head. And then finally, this clear communication, which I kind of alluded to before. Employees need to know that if there's an issue, there's open communication, positive and negative, coming from the supervisor. And then there's also an obligation to maintain it, right? So this means that we have to ensure that we're doing the right things. And on the slide, you'll see this perpetuation and escalation. In situations where the supervisor is not actively engaged, it causes the problems to kind of fester, and it escalates and it gets worse. And then you have problems with team morale and retention. You have the issue of one supervisor not taking care of an employee and then that person going and getting another job, and the new supervisor inherits that poorly performing employee who has not been managed or given an opportunity to succeed. So it comes out in a lot of ways. Obviously, there are customer and patient impacts. And then finally, this issue of stewardship, where we do work for a public institution, right? And so a lot of our funding comes from the state. We need to make sure we're doing the right thing with our funding. Okay, performance management, just very quickly, this is the spectrum or the graphic on the right is the thing that the Office of the President puts on their website. It kind of shows how this performance management cycle works. But basically, there's all these different things that we do, right? We coach, we mentor, we counsel, we do your annual performance appraisal. And then as you get down to the bottom here, you'll see in red where it says discipline and then just cause. That's really what we're talking about today. None of the rest of it requires the university to have just cause, to counsel, to issue a performance appraisal, to, Mike just died, I thought, issue a letter of expectations. For just cause, we're only talking about the disciplinary spectrum, which are letters of warning, suspension, dismissals, and demotions. Okay, so this is where the rubber hits the road. So there's a book written in the 70s about the 7 tests of just cause. I've distilled them here. So 3 things. Is the rule under which the employee is disciplined known, fair, and evenly enforced? And I'll walk through each one of these a little bit more. Number 2, did the employee engage in the misconduct or the performance failure? And number 3, is the penalty reasonable given the employee's entire work history? So just cause 1. Okay, something to note for supervisors and managers, all of this precedes a performance concern. This just means that you are properly managing your work environment and supervising your work environment, because you should have all of these boxes kind of checked in advance of any performance issue. So it needs to be a reasonable rule. We typically have very good policies here, but if the supervisor created a local work rule or something in their unit that said everybody has to wear a tie on Thursdays, and then someone didn't wear a tie on that Thursday, and then they tried to issue discipline, that would be concerning, because there's no really legitimate business reason that the people would have to be wearing the tie on Thursdays. So it can't be arbitrary. Second, known, and you'll notice that I have it's kind of known squared. There's 2 components of this. The rule has to be known by the employee, and they have to know that they could receive discipline for having violated it, right? And then it has to be fairly enforced. You can't pick and choose who you enforce your rules against. Everybody has to be treated similarly. So non-disparate means that you don't just play favorites, right? You don't just, for whatever reason, issue discipline to one person and not somebody else. And then it can't be discriminatory, right? So it can't be based upon someone being a member of a protected class or having engaged in a protected activity. Number 2, we need to know that they actually engaged in the workplace misconduct or the performance failure. And that means we need to perform a full and fair investigation. Now, I hesitate to use the word investigation because Sometimes people think investigation means that you have to hire some outside entity, or it has to go to the Office of Compliance, or my office has to be engaged. A full and fair investigation just means that it has these components, right? So the employee has to have an opportunity to respond. It's not fair, again, fundamental fairness, it's not fair to an employee to pull them into an office and hand them a disciplinary action if they haven't had an opportunity to respond to the allegations against them. I would note that there are these things called Weingarten rights, which is the right of a represented staff member to have a union rep with them in an investigatory interview. There are similar rights for non-represented staff, but if, as a supervisor, you go to interview someone, when I say interview, I mean if that conversation could lead to discipline, pretty much that means that they have Weingarten rights. And so if they ask for a union representative, you're going to have to hold off on having that meeting for a day or two until we can make sure that a union representative is available. We should be looking at all relevant witnesses and all relevant documents. We can't cherry pick and choose what we want out of it. We have to look at all of the, to throw out the lawyer language, the inculpatory and the exculpatory evidence. We have to see what supports discipline and what would mitigate or argue against issuing discipline. The investigator, quote unquote, needs to be unbiased. Frequently, frankly, it is the supervisor, right? If the supervisor observes the conduct, frequently it's going to be the supervisor saying, I just saw you do this. Why did you do that? And if the employee says, I'm really sorry, I just had my medication changed and I'm feeling a little dizzy. Well, then we need to have a conversation about, what's going on. If it's a patient care environment, obviously we can't have folks that are dizzy in the workplace. And then we go down that road of having the conversation about why the person's having the performance failure. But again, it needs to be an unbiased investigator. It needs to happen in a timely fashion. And it needs to be conducted prior to determining whether discipline is appropriate, right? It can't be, hey, we're going to do this investigation. We should be done by Thursday. We'll issue the letter on Friday. We can't say that because we don't know that we're issuing the letter on Friday because we haven't completed the investigation. And finally, number 3, and then the investigation has to yield substantial and persuasive evidence, right? So it's a 51% standard. So we weigh all the evidence, and if it's more likely than not that, Susie no-call, no-showed last week, then we would deem that to have happened. And then finally, a reasonable penalty. And this is based on the employee's entire work history. So we're talking about years of service, we're talking about historical performance and whether the concerns have been raised in their performance appraisals. We're talking about prior similar discipline, whether there's mitigation or aggravation aggravating circumstances, whether the conduct is egregious, and the severity of the impact on the institution or on the public. And I've highlighted egregiousness because it is not infrequent that we have a situation where an employee has engaged in something so egregious, whether it is workplace violence, harassment, that are egregious misconduct, and you don't get, you don't get to steal $50,000 and then get a letter of warning and then do it again and then get a letter of suspension and then finally lose your job, right? There are things that are not required to go through a progressive disciplinary standard. Employees have a right of appeal, right? So represented staff have the right to appeal a grievance pursuant to the collective bargaining agreements. They can file them individually or the union can file them on their behalf. In our next seminar, we're going to talk about the disciplinary process. I'm going to go through this a little bit more, but these are filed with labor relations. And non-represented staff have a similar right under personnel policies for staff member 70 that they can file a complaint, and that also comes to our office. And then finally, so how does just cause support a respectful and fair workplace? Again, certainty and fairness to staff, right? Non-arbitrary, non-capricious, non-disparate, non-discriminatory actions. That we're treating people as we would want to be treated, and we're not singling them out for discipline. This improves team morale and performance, retention, recruitment. We have a recruiter, at least one recruiter in the room, so she probably has encountered this and seen this, that when we're trying to attract people, if we have a bad reputation about how we treat our people, that's not helpful to us. Also, disciplinary actions have serious impacts on the staff that are receiving it. They shouldn't be taken lightly, right? We should do the right thing. And it also places the responsibility appropriately on management to do the right thing, because management has the obligation to make sure that we are following a just cause standard. And if we don't, there are processes for filing grievances or complaints to challenge them. Okay, I went through a heck of a lot of stuff, and I did it in exactly 20 minutes. Oh my, check me out. Okay, so this slide, I thought it'd be helpful to leave kind of the three pieces of the just cause rule up there so people can ask questions about them. And now I've left 40 minutes. Does anybody have any questions?
Can you elaborate on non-disparate? So if you're in a scenario where you're overseeing staff at different levels and have different expectations of that different staff, you know, how, and kind of that even enforcement, some of the challenges you might have with different staff levels.
Sure. So when so I'm not sure it was heard, but the question was, can I elaborate on the non-disparate component of just cause rule number one? And if you have different levels of staff with different levels of authority or expectations, how you balance that with not treating them differently than you would treat other staff? It's a good question. So you start with a position description that describes what that employee's roles and responsibilities are, and then you hold them to those roles and responsibilities, right? If you have someone who is at an executive director level versus someone who is at a line staff level, clearly the expectations for their scope of work are going to be very different. Also, as I mentioned, as you get further up in the organization, you end up in manager and senior professional grade, which actually they don't have a just cause standard. So the folks at higher levels of management in the organization are held to a lower standard, but the standard for issuing them discipline is lower, so it's easier to issue discipline to them. But with respect to dealing with the disparate treatment, it's substantially similarly located folks, right? So if you have two folks that are doing basically the same level of work in the organization, and you're all over one person about, what about this timeline? And I heard you talk, inappropriately to somebody on the phone, and what about this and what about that? And the other person you're kind of ignoring, it's not going to be okay. And that's going to be a micromanagement piece, but then you're going to be issuing discipline, right? And one of the questions that we ask in ELR is, when we get a draft letter from the department or from the HR business partner, and it says, Susie used a computer that she wasn't supposed to use, and everybody knows, we've told everybody that they're not allowed to use that computer. A question that we would ask is anybody else in the department using that computer, and they're singling Susie out for discipline? And that's a question that we ask, and we get verification back from the department before we sign off on including that in a disciplinary letter, because it's important that if you're holding people accountable to things and issuing discipline for them, that it's uniform across the workplace. I'm not sure if I'm answering your question.
Yeah.
So that doesn't mean that someone who's in a supervisory role, they have different responsibilities, right? I mean, if you have someone in a supervisory role who is not doing the things I've talked about today, building a respectful and fair workplace and not treating people fairly or treating people differently or discriminatorily, that's part of their job. And so you'd be holding them accountable to a different thing than you'd be holding the line staff to, but it's because their job is different. I hope I answered your question.
Yeah. I mean, it was more about, like you said, enforcing that position or standardizing that working your managerial plan to a position description rather than, even if you have staff that are doing different work, I guess.
I'm not sure I understand. I'm sorry.
You answered my question.
Okay. Thank you. Okay, something online. So what do we do if the department doesn't feel like it has a fair and evenly enforced workplace? So I'm assuming that What do we do if the department doesn't feel? So I'm assuming that this question is coming from a line staff member who feels that the workplace is not fair and that they're being treated unfairly. So the short answer, well, there is no short answer, so I'll just talk. You have a variety of options, okay? So we have different resources that are available at the university to support staff in these situations. We have an ombuds office, okay? It's a confidential service. You can reach out to the ombuds. I don't think I have that in my resources in my later slide, but we can circulate that information. The ombuds is wonderful because that office is able to really help you kind of think through the things that are concerning you and provide the resources that are available, whether that is through a grievance process or whether that is through elevating it to management, whether it's providing a mediated conversation with a supervisor. So the Ombuds Office is one resource you can use. You can also use our ASAP services, which there's an office on each campus. This is the Academic and Staff Assistance Program. These are our counselors. It's, again, a completely confidential service. Both the Ombuds and ASAP, they can't even tell management whether anybody went there. It is completely confidential and safe environment for you to go and ask the questions about what's available to you as far as rights. If you're concerned about going to your boss, obviously, or if you're concerned about coming to Employee and Labor Relations. I would say that Employee and Labor Relations is another option for you. And I know that there are times when ELR gets a bad rap and that we're all supportive of management, but not employees. I'm here to tell you that's not my vision of what we are supposed to be doing. Our job is to make sure that we are adhering to and that the university is adhering to the terms and conditions that we have memorialized in our collective bargaining agreements and in our policies, and that we're doing so in a way that builds a respectful and fair workplace. So on the slide that I'll show at the end of this, it shows how to get to the contact information for the employee relations consultants for each campus. And that would be a starting point. You could call that person even anonymously, and it's broken down by department, so you know which person to call based upon department. You can call that person and give them, look, this is what's happening in my department and I don't know what to do. And that person on my team can help you strategize about what you can do and what you can't do. And sometimes we learn incredibly important information that way. Sometimes we learn about misuse issues that we forward to the Office of Compliance or the Office of Counsel or Risk. So there are resources available, and I know that this is one of the core concerns, that employees don't feel empowered to do these things and they fear retaliation. So remember in the conversation that I had, or the description I had earlier, that it needs to be, when we're taking a disciplinary action, one of the things that we look at is this retaliatory? Did this person engage in a protected activity or are they in a protected class? If you make a complaint, that's a protected activity. You should not be retaliated against for making a complaint against your supervisor, right? And we look out for those things. So I'm not sure I answered the question fully because the person's online, but those would be the resources that I would look at. Questions? Yeah.
I don't know if this is a quick question, but how do you prove retaliation exactly? Like what?
Great question.
Exactly. Because I've heard of different things here and there.
Yeah.
And I think, oh, that's an open-ended shut case, but then it's not been proven.
Yep. So the question is, how do you prove retaliation? And it can be a difficult thing, right? Because what retaliation is if the university takes an adverse employment action against one of its employees, so a disciplinary action or, transfers them to our, Arctic research station or whatever it is, that is taken because they engaged in a protected activity, right? So you have three elements. You have someone engaging in a protected activity, then receiving an adverse employment action, and then a linkage between those two things that one was caused by the other, right? So the because is the hard thing to prove sometimes. One thing that the courts look at, and to be clear, I'm not counsel for the university, so I'm not providing legal advice. But one of the primary things the court look is the timing. So if somebody receives, Susie calls her supervisor and says, I think Joe is stealing and it makes me really nervous. And it turns out that Joe is the supervisor's best friend. And then Susie gets a disciplinary action the next week. We look at the timing of when that adverse action hits versus when they engage in the protected activity. The closer they are together in time, the stronger the inference that one is caused by the other. We also look at other factors, right? If Susie had been a stellar employee with perfect EPARs forever, then she made this complaint about a coworker stealing, and then in her next performance appraisal, all of a sudden, even though Susie's been here for 12 years and has been fantastic the whole time, all of a sudden the supervisor blasts Susie in her EPAR. We look at those, and then she files a complaint or a grievance. When we're looking at it, those are the things we look at. Look, she has this massive history of being successful, and then the only thing that seems to have changed is that she engaged in this protected activity. So those are the ways we try to draw the linkages to figure out if Susie actually just isn't as good an employee as she used to be, or whether she engaged in a protected activity and now she's paying the price for it. And I got to tell you that when we talk about this egregious misconduct and ramping discipline, retaliation is right there. The university does not look kindly on retaliation. When I get retaliation complaints that come across my desk, I promise you the starting point is not a letter of warning. We're looking at a higher level of action to suspension or termination. It's unacceptable when people take the risks to the benefit of the institution to go out and say, I noticed this terrible thing happening. For that person then to have their voice squelched is unacceptable. Other questions?
So, how are we doing as an organization where Just Cause is concerned? The employees, managers, supervisors, because I think, to be honest, there are instances where that kind of thing does happen and where a supervisor or manager may be very methodical with regard, and it may not be, this time span of a week or 2 weeks where a letter of warning is issued. It may be maybe a couple months down the road where these things start happening where the employee is concerned. But it's not this short time frame. It's a very methodical process that one may be taking.
Yes.
To,
Yeah, so the question is, how are we doing as an institution with respect to Just Cause? And then more specifically, how are we doing with respect to policing, whether or not supervisors engaging in retaliatory behavior, if that supervisor is patient and takes her time and retaliates a year later instead of, in close proximity. So hard question to answer, right? So the answer to how are we doing with Just Cause is varied, right? So we strive, I believe, mightily to make sure that we are establishing a singular lens through which the institution, and now since we're combined across both campuses, how the entire institution looks at Just Cause through a similar lens, right? That doesn't mean that there aren't pockets out there of supervisors that are taking actions that maybe we don't know about, that we discover later that are problematic, or that we don't discover, and then that's problematic also. But certainly the philosophy is uniform across the two campuses. The goals of building the respectful and fair workplace through a Just Cause standard is uniform across the two campuses. As far as the question about what about the sneaky supervisor who waits, I'm trying to make it appear that it's not retaliatory. I have seen very patient people in my job. I have seen employees who engage in misconduct, receive a letter of warning, engage in the same misconduct, get a suspension, and then are fantastic employees for 3 years, and then engage in the same misconduct, get a letter of warning. So there are people that have the ability to polish up their act and then choose not to. And likewise, I've seen supervisors who have been able to try to deflect or otherwise camouflage their intent. Can I say we catch all of those? I can't. I don't know. I know that we look for it really, really closely, because retaliation, when it comes to civil litigation, retaliation is a really difficult claim to deal with in civil litigation. And so there's risk attached to it. And so, my office works very closely with the Office of Risk and with the Office of the Campus Counsel. And we work really hard on issue spotting, where we see someone who's engaged in a protected activity. The next questions are these two things linked? Is there any way these two things could be linked? Or do we have non-discriminatory, non-retaliatory, justifiable business reasons for taking the action that is being taken? And if not, then we look at it even more closely. With that.
One last thing.
Yeah, well, okay.
Okay, so are you sensing that we are now operating in an environment where employees believe that things are fair? Or do you think that there's still this level of fear that employees are kind of operating?
So I'm not close enough to know, but I would doubt that we're there. I would doubt that we're in a place where all employees feel empowered and that they're operating without fear. I don't have any facts to back that up, but just kind of intuitively, staff employees are embedded in their units, and the only people that they're primarily working with are going to be their direct supervisors and the chain of management for their unit or their department. And that can feel isolating. And that all of the power around them, if they perceive that they're being treated unfairly, I think it'd be hard for them to necessarily understand that they do have rights and that they do have resources. And frankly, that's one of the reasons why we're doing this series, is because we're trying to get the word out there that people do have resources and people do have rights in their workplace. So do I think we're there? I don't, but we're working on it.
A question from online. What is ELR's preference for discussing/addressing confidential matters? That department managers contact ELR directly or to work through the division?
So I'm not sure how to answer that question. So I guess the starting point is the confidentiality piece, right? So pretty much everything we deal with is confidential, right? It's either bargaining confidential or grievance confidential or arbitration confidential or performance management confidential. So when you ask the question, would we prefer that you work directly with us or departmentally? I'm gonna have to cop out and give the lawyer answer. It depends, right? So there are lots of places across both campuses that have embedded HR support as HR business partners, as HR managers, as administrative managers embedded. Those folks have a level of HR support and expertise to be able to help with these things at the departmental level. So usually the model is that when there's a local issue, it first goes to that local HR support function, and then as it progresses or as it becomes more severe, then it ends up coming to the central units, whether that's comp, classification, recruitment, ELR, whatever it is. But the starting point is the local resource. Having said that, there are times when there are concerns from the department, whether it's with the supervisor or manager or whether it's with the staff, that they cannot, that their embedded person already has information about what they want to talk about that could bias them. And that's not a knock on the folks that are HR business partners, but they're living in that space. And so I could understand how an employee could feel that there was a bias there. And so we want to make sure that we get reporting, right? Where there are concerns, we want people to reach out and get resources and get support. So to the extent that there are, limited instances where there are those concerns, you're always welcome to call ELR. It might get referred back to the business partner as appropriate, but the starting point is normally the business partner or the embedded resource, but we're always here as well. I hope I answered that.
Let me answer one more online. Is that it?
Okay. Other questions? We got 20 minutes, folks. Do you want me to walk through my scenario? Okay, I'll do that. So let me walk through these slides first. So here are some resources for you. So how you contact employee relations consultant, those are the links. Where do I find policies and collective bargaining agreements? There's that link. And again, we're going to post all this on our website, right? So if you're a member of a collective bargaining agreement, you don't know how to find your contract, it's right there, as are all the personnel policies for non-represented staff. And then what resource do I have if I'm stressed out or dealing with a medical condition or disability? Here are ASAP services, both for the Davis campus and Davis Health, and disability management services for both sides. So thank you. We'll get just with the slide order, the thank you comes first because I didn't know we would get to the scenario. So remember that our satisfaction survey ends tomorrow. So please, I know everybody has received this in their email. Please respond to that. Our next ELR seminar is going to be April 16th. It's going to be understanding the disciplinary process. That includes, the issuance of discipline, the Skelly review, the grievance process or complaint resolution process, arbitration, that whole spectrum. And that's going to be in the Davis campus from 12 to 1 on April 16th. Okay, let's talk about a scenario. You need one more click. There it is. Okay, so Chris, you're in trouble, right? So walking through this. Hired as an SRA1, which is a represented title, in 2008. Got a promotion in 2012. Issued a letter of expectations for excessive tardiness in 2013. Issued a letter of warning for excessive tardiness, so this looks progressive, a couple months later. Accepted a promotion 2 years after that. And then in 2019, was issued a letter of expectations, again for excessive tardiness, and a couple weeks later arrives 2 hours late for work. Then is issued a letter of warning for excessive tardiness, and a couple weeks later files a grievance citing a violation of just cause. Anybody want to opine as to whether or not they have any concerns with this timeline based on a just cause standard? So, in the deafening silence, I will point out one thing. The date that the person arrived late to work, 2 hours late for work, was on the 28th of February, and they got issued their notice or their letter of warning the very next day for excessive tardiness. This would cause me concern if I saw this fact pattern. Because, just cause number 2, we have to do a full and fair investigation. Usually, our investigations at the university don't happen quite that fast. So this feels to me like the supervisor may have had this thing kind of locked and loaded and ready to go and was, issuing immediately upon the person returning to work. So this feels like there might be something else going on here besides just the fact that the person was late. So let's add a fact and see what we get from there. Wait, I have a question. What are the work rules regarding work hours? Is it applied to everyone? So that's a good point too, right? So obviously with a bare bones question like this, it's impossible to include all of the facts. So let's operate on the assumption that the work rule is fair and appropriate, is being evenly applied until we get facts that would say otherwise.
Yeah. Then are you also operating under the assumption that it's the same supervisor the entire time?
I'm not.
So could be a different
It
department?
could be a different department, different supervisor.
Okay. So then I have an issue then with the letter of expectation on the 12th of February. If in fact it isn't the same supervisor, same department,
Why?
because he just accepted the position on the 1st of March.
That's 2016.
Yeah.
Yeah,
So
but
what,
it-
so what's happened?
3 years later, they got the letter of expectation.
Why? Because if he accepted the SRA 3 and it's another
Yeah,
department,
but in 2016, and then something happened 3 years later that there were concerns with the,
yeah, I would want to know what those concerns are.
yeah, again, I can't go into all, I haven't included all of the facts. We could dive into whether or not the letters of expectation are appropriate, but remember, letters of expectation do not require just cause standard. This is just the supervisor writing an email saying, or I'm sorry, writing a letter saying, here are the dates that you've been tardy. This is a violation of our policy. These are my expectations. It doesn't go in the permanent personnel file. It goes in the supervisor file, but it's not in the permanent personnel file. And there's not a just cause standard for it. So something happened leading up to the February 12th, 2019, that caused the supervisor to issue a letter of expectations. Okay, so let's add a fact. Please, there we go. Okay, here's a new fact. Unbeknownst to her supervisor, Chris's tardiness on the 28th of February resulted from being in an auto accident on the way to work. When Chris was issued the letter of warning, she told her supervisor about the accident, to which Chris's supervisor responded, quote, "Your personal problems are not my concern. I expect you to be at work on time." Anybody have any concerns with any of this? Okay, so it's good that we have concerns with it, but can we couch it in terms of just cause?
Fair and agreed.
Right.
Apply that same standard.
So we don't have any evidence that it's non-disparate.
But you would, when in your investigations, you would have asked why you were late, I would assume. So you would have known that before issuing the letter.
Yeah, so the somebody in the room, I don't know if it was heard for the folks online, said that in the course of your investigation, you should have gotten this information that should have been considered before issuing the letter of warning. So that's exactly right. And the first word of this paragraph really says it all, right? Unbeknownst to the supervisor. That means the supervisor hadn't spoken with the employee yet. And that's just not okay. You don't issue discipline to somebody without giving them an opportunity, a full and fair opportunity to respond to the specific things that they're alleged to have done that are violative of policy, right? So the fact that it was unbeknownst to her supervisor means that she has not completed just cause number 2, which is complete a full and fair investigation into what happened and give the person an opportunity to respond. That yields substantial and persuasive evidence, that supports the action. And then, of course, we have this other gem at the end here, right? You know, that your personal problems are not my concern. Clearly, you know, we have a supervisor here who is not understanding their role in building a respectful and fair workplace, right? So that isn't a component of the just cause piece of it, but it's certainly a component of, we have a supervisor who is not making good decisions in how he or she is communicating. Okay, so forget that fact pattern completely, and now we're going to do the next fact pattern. So this one did not happen, now this one happened. Chris's supervisor avoided talking to Chris about her tardiness, then issued Chris the letter of warning in June of 2019 without speaking to Chris's coworker who was with Chris on the date that she was late. What are our just cause problems with this fact pattern? So 2 things, and the folks in the room picked up on both of them. One is that it is not timely, right? So now we have someone who the fact that they were 2 hours late was ignored for 4 months. And then they were just out of the blue issued a letter of warning, and they didn't speak with Chris. At least they avoided talking to Chris about it, and they didn't speak to Chris's coworker. So this is the whole inculpatory and exculpatory evidence, right? The good evidence and the bad evidence, depending on which way you're looking at it, right? So if there is evidence out there that we know about that would be relevant to us or material to us in making a decision about whether or not there's just cause, we have to investigate that. And so if Chris had said, you know, John was with me, you should go talk to him because I was in a car accident. We would have to go and talk to John and confirm John's perspective. Okay, then one more. For 18 months, Chris's supervisor has allowed Chris a flexible schedule on Thursdays to attend a personal meeting. On the 20th of March, Chris's supervisor informs Chris she no longer approves her flexible schedule. Marilyn, what does that look like? So for those online, someone in the room named Marilyn had asked a question about retaliation earlier. And so, clearly we have someone who had a flexible schedule and now it's been removed coincidentally 3 weeks after, or 5 days actually, after the employee filed the grievance. Filing the grievance is a protected activity, and now we have this possibly retaliatory act. So if this came to us in ELR, what we would do is we would ask all the questions around why now? Why does this flexible schedule need to go away right now? And if the department says, well, we've been thinking about it for a while and we've just decided we don't like flex schedules anymore and so we need to do away with them. It's not a great answer, right? If the answer is, we have a specific project that we just got grant funding for, that we're on a limited timeline to implement, and we have to do it within that timeline or we lose the funding. And so I need everybody to work their normal standard hours for the next 3 months to make sure that we can achieve our goals through this grant funding. And then after that, we'll go back and let people have their flex schedules. That, to me, feels like a non-discriminatory, non-retaliatory, justifiable business reason for taking away the flexible schedules. The employee may still feel like they're being retaliated against. And so communication is going to be really important for that department to make sure that people don't feel like they're being singled out or retaliated against. But there certainly could be a reason, but it would raise eyebrows with my team because of the timing, because it's 5 days after the filing. Yeah.
So what does the supervisor have to? So the proper way to do it would be like a position adjustment or like notify the employee this is what's gonna happen starting this date. Your new times will be this. Is that how you go about doing that? Because
So
would it be the supervisor's prerogative to say you can't do your new hours?
So it is certainly with flex schedules so the question was, how would that communication look, and does the supervisor have the right just to say, we're taking away the flex hours? So flexible schedules are not guaranteed at the university. We try to do that in instances where we can because it's a work-life balance thing and it provides a benefit to the employee and it builds out a respectful and fair workplace so long as the work can still be completed and the mission can be advanced, right? As far as how to communicate it, if ELR found out about the desire to remove the flex schedule, so let's say the grievance is filed on the 15th. We forward a copy of the grievance to the supervisor for response at the step 1 level. And she says, oh, by the way, I'm going to be removing this person's flexible schedule. Is that a problem? We're going to say, yeah. Why are you removing the flexible schedule? And then we'll talk about it. And if it's the first scenario that I described, which is we've been thinking about this for a while and we're just going to do it, we're going to advise not to do it because there's no business reason right then to do it. And it just looks retaliatory. If there is a justifiable business reason for doing it, then what we will do is explore how we communicate it, not just to that employee, but to the whole team. Let's do some kind of a team meeting. Everybody knows we were applying for this grant. We got the grant, but we are on a short timeline for implementation. I know this is going to be impactful to everybody, but we're going to have to get rid of the flex schedules just for 3 months. We'll bring them back afterwards, but we have to get rid of them for the next 3 months. Or maybe it's permanent, maybe, whatever it is. But we would look at having the communication in an open and transparent way that describes why management has to take these actions, instead of just a one-off conversation with the supervisor and the person that just filed the grievance saying, oh, by the way, your flex schedule is being rescinded. Does that help?
Yeah. I guess I was asking. I guess I was asking more not necessarily for this, this situation, just more in general. Like if I wanted to say you no longer have flex schedule, we need to start reporting to work at this time and clock out at this time. Do I have that right? I guess it's more.
You
are
have the
there
right to
certain
do that.
steps that I need to take.
Okay, so the question is just more broad, and it's just as a supervisor, can I rescind a flexible schedule? You'll want to look at whatever the agreement is that typically we sign a document, and that document describes that it can be unwound, but you'd want to look at exactly what the department had agreed to in advance. And then you probably want to reach out to Employee and Labor Relations or your HR business partner and have a conversation with them, because if there is anything rattling in the background of it, these are the kind of things that are, because they are unilaterally in control of the supervisor, they're the simplest thing for a supervisor to do that could be retaliatory. So we want to just look at it really closely and make sure that there's not something else going on in the background. But if there's a business reason to do it, then you can do it. We may have to have conversations with them, because if their flex schedule was that they're working 9/8/80s or something, and so they get one day off every 2 weeks, and they are taking a class that day or something, we might have to have conversations about the impacts to them and figure out the timing of doing it. But, the business partners and our office can help with those things. What's my time look like?
3 minutes.
I got 3 minutes. Questions, anybody?
It's the microphones, nobody wants to talk.
Okay, so I can give you back 3 minutes of your time if there are any other questions. I know I went through the 20 minutes really, really quickly. Again, we'll post all this stuff online. You feel free to pose questions to anybody on my team about this, or to me directly. With the labor excitement that's going on right now, there might be a lag in response, but encourage folks to ask questions, and would very much appreciate, again, any feedback that you're willing to give about the technology behind this, the substance of this seminar. Was it helpful? Was it not helpful? What we can do to improve it. We, again, are looking at doing this at least for the next several months, hopefully beyond that. And so whatever we can do to improve it, we would very much like to do. So thank you, everybody. I appreciate you giving me your lunch hour. Have a great day.